afternoon.
Yes, good evening, everyone. Welcome to our subcommittee meeting. The quantity surveyors held this. It is not only meant for quantity surveyors, though. It is to get a understanding of some of the points for the new procurement law. So, Mr. Derek Outridge is our speaker today, as we have seen on the board. He got his information, the extracts from a thesis of, well, not all of the information, but his portfolio. He's a quantity surveyor and his profession is in law. He has a lot of knowledge as pertains to valuation and such as well. So let me leave him to take over from here. And thank you again for being here today to join us.
Good afternoon, colleagues. I know many of you are interested in the public, Procurement Act. One of the things I've done, I've decided to particularly home into what is called the Office of the Procurement Regulations. And I'm going to identify select clauses that deals particularly with the OPR and to explain why those clauses are there and probably some of the constraints in the clauses. The extracts of these slides have come from the thesis of University of Nottingham, UK Masters in Law, dissertation 2019 of Sonia Gann, an attorney at law, good colleague of mine, who has willingly consented to the presentation of this information to you all. The thesis was entitled Trinidad and Tobago's Office of Procurement Regulations, Can It Solve Our Public Procurement Problems? So, kicking right off, 2015, the government of the Republic of Trinidad and Tobago took a bold and significant step to properly regulate the area of public procurement by passing a comprehensive legal framework, namely the Public Procurement and Disposal of Public Property Act, 2015. And I'm going to refer to that, henceforth as PPDPPA, which when fully implemented would repeal the Central Tenders Board and it would create an independent institution of the Office of Procurement Regulations, the OPR. So it is hoped that this public regulatory body will correct the ills of what was a decentralized system of operation that created a waste of labor, a waste of time, and a waste of cost resources. As was identified in the Commission of Inquiry 2010, the Central Tenders Board Act of 1961. And you will particularly enjoy this part. It was amended by piecemeal development over the several decades. And that allowed the government of Trinidad and Tobago to circumvent the Central Tenders Board and act on its own in different circumstances, which included in 1979, when the procuring of goods and services where the government of Trinidad and Tobago entered into an agreement with a foreign country. We know that as G2G, government to government arrangements. In 1987, where an emergency or natural disaster occurred, so they didn't have to come to the Central Tenders Board for that. In 1993, where the government of the Republic of Trinidad and Tobago contracted with special state-owned companies. We know those are special purpose companies. And a total of about 32 of them. So the result was that the government of the Republic of Trinidad and Tobago was allowed to design its call for tenders in a way that ensured that the contract went to its chosen supplier and to create parallel procurement undertaking bodies, such as, well, we knew the first one was NIPTEC, and now the 32 other special purpose companies, which includes UDICOT, NITCO, ETEC, EFCL, and many others. So the Office Commission of Inquiry in its report also identified that the legislation governing the Central Tenders Board was universally perceived as imposing unnecessary constraints and bureaucracy, leading to delay and inefficiency. So as such, special purpose companies fell outside the jurisdiction of the legislation, that is the Central Tenders Board, and were often incorporated by the government directly, for projects in accordance with their own non-transparent procurement procedures, thereby circumventing the Central Tenders Board. So due to these deficiencies, and under that archaic Central Tenders Board Act of 1961, the PPDPPA was assented to on the 14th of January 2015, with the aim to repeal the Central Tenders Board Act and to reform the entire national system of public procurement. And so today, only certain sections of this act are proclaimed, including those establishing the OPR. So whilst it's been assented to, several sections have not yet been proclaimed. And the only way for them to come into effect, assent gives it law, makes it law, but proclamation is what makes it operate. And the lack of proclamation means that the whole aspect of the PPDPA cannot function. So the policy objectives of the PPDPA are to undertake public procurement, having regard to good governance principles comprising, and you would see transparency, integrity, value for money, and accountability, as well as efficiency, fairness, equity, public confidence, local industry development, sustainable procurement, and sustainable development. All of these are in the Act under section 5.1. So where you see I wrote section or SS subsection, you can find these in this actual statement in the Act itself. So this is the governing principle that the Act says it must do. So public body must now carry out their procurement activities in keeping with these objects. Failing which, the resulting contract shall be deemed void and illegal. Section 6.1 says so. So the JCC, for the construction industry, Joint Consultative Council Committee, the Trinidad and Tobago Chamber of Industry and Commerce, the Trinidad and Tobago Coalition of Services Industry, the Trinidad and Tobago Manufacturers Association, as well as the Parliament of Trinidad and Tobago, exposed that the PPA was in fact anti-corruption law. The Office of the Procurement Regulation, the OPR, is one of the major hallmarks of the PPA and is the establishment and development of what is called a central institution body known as the OPR, which has essentially been given the mandate of implementing the Trinidad and Tobago's national public procurement system reform, and that is in section 9 of the Act. Its function and powers as defined by the statute are wide in that they govern all stages of public procurement, and they require a significant degree of independence from the government, as they include capacity development, advisory services to procuring entities, monitoring procurement procedures, auditing public bodies and the procurement system, and ensuring compliance and investigating public bodies for purported breaches of the Act. And that is in subsections 13 and 14 of the Act. So a lot of people talk a lot of stuff about the Procurement Act, but very few of them can have pointed out to us exactly where in the Act these provisions lie. And so my presentation here today is more or less to point you all out to this act. The act has 67 clauses, and to point out some of these sections, very important for the operation of the, so and we all can understand more and to be in respect. Central body like the OPA is as a public is constantly, especially so for small development area. OPR maybe the deal with the implication, enhancing transparency. And it can of increasing public confidence in the it was given significant power and influence over of any ministry, any governmental body. Sorry about that. I gotta move it all the way down so I could see what I'm looking at. All right. The key advantage of this placement is in the administrative structure is that it is and is seen to be independent from the government of the Republic of Trinidad and Tobago. So it is therefore akin to that of a service commission under the Constitution of Trinidad and Tobago, which is likewise free from the control of any external authority and has autonomous power over its functions, including the appointment and removal of public officers. The Constitution of the Republic of Trinidad, Act number 4 of 1976, section 121, covers that of a service commission. And Lord Diplock held in the Privy Council case, Endell Thomas v. the Attorney General of Trinidad and Tobago, 1982, Appeal Court 113-124, that these service commissions were politically insulated and free from political interference. The OPR is to be governed by a board. That is in section 10 of the Act. And the PPD-PPA stipulates that members of the board, ranging from 8 to 11 persons, are to be appointed by the Trinidad and Tobago's head of state, the president, subsequent to consultation with the prime minister and the leader of the opposition, section 10.1 of the Act. As to termination of members of the board, it is solely the responsibility of the president to remove members of the board upon being satisfied that one of several conditions, including bankruptcy, incapability, neglect of duty, convictions of various offenses, which is stated in Act number 5, the amendment of 2016, section 12.1. And for trading with government without prior approval of the Minister of Finance, section 12.2 of the Act. So those are the conditions under which members of the board can be removed by the president. So while there is obvious need for accountability of actions of the members, protection of members from arbitrary removal, especially in the case of its chairman, is fundamental to ensuring that the functions and powers of the office are carried out effectively and without political bias, thereby promoting efficiency, integrity, and longevity of the national procurement system. These considerations of accountability versus security of tenure are conflicting and must be cautiously balanced in the legislation. For the first time in Trinidad and Tobago's history, there was the creation of an independent procurement regulator, who is also the chairman of the board and free from executive control. The first procurement regulator was appointed in January of 2018. In relation to the functions, the regulator is a full-time position, and the appointee is entrusted with the day-to-day management, administration, direction, and control of the business of the office. That's under Section 11(2) of the Act. The regulator is given wide powers, and the proper performance of these functions presupposes a fiercely independent, strong, dedicated regulator who is immune to corruption and political interference. So under the Act, the regulator's responsibilities aim primarily to give effect to the objectives of accountability, integrity, efficiency, and transparency. The regulator is also, inter alia, mandated to audit and monitor the procurement system. And he does this by the submission of annual reports to the Speaker of the House, the President of the Senate, and the Minister of Finance on matters including the total value of contracts awarded by public bodies, the public bodies that have failed to comply with the Act, and an assessment of the overall performance of the procurement system, Section 24 of the Act. The regulator is required to have at least 10 years experience in procurement and a degree from an accredited university in finance, economics, law, or accounting. And that's in Section 10(1)(a) of the Act. The other 7 to 10 are part-time members of the board, and they are required to have qualifications and experience in accounting, finance, business management, civil engineering, law, and any other field relating to procurement, and other representatives with specific interests in the community, women, youth, religion, or civil society. And that's subsections 10(b) to (h) of the Act. So the procurement regulator's term shall be 5 years, with the option of reappointment with the caveat that a regulator cannot serve more than 2 consecutive terms. And that is the amendment that took place, Act number 3 of 2017, Section 11(1). The limitations and stipulations on the tenure of the regulator aim to prevent the possibility of dictatorship within the structure of the OPR and the risks associated with conflicts of interest. It protects against established relationships with outside actors, including suppliers and the government, which are open to favoritism, abuse, and corruption, thereby ensuring the independence of the body. So, looking at the monitoring, investigatory, and enforcement functions and powers, the OPR is charged with the vital powers found in any effective national procurement system of monitoring public procurement, conducting audits and inspection, and issuing directions to public bodies to ensure compliance, Section 14 of the Act. The OPR is further mandated to investigate whether on its own initiative or upon a complaint from any involved party or member of the public, an alleged or suspected breach of the Act, Section 13(1)(n) of the Act. And that's a powerful statement. Eh? It can act on its own initiative, even when it doesn't have a complaint, or it can act upon a complaint. And it doesn't have to wait until there's evidence of the actual act committed. it could be an allegation or suspected breach, where a member of public has brought that to its attention, or where on its own initiative it can operate that. That's section 13(1)(n) of the Act. That's a significant portion of the Act. As to its monitoring power, notwithstanding that it ensures improvements to the system, they are predicated on burdensome information collecting and reporting requirements, and its more bureaucratic procedures, which can be cost and labor intensive. As to its investigatory powers, the legislature has effectively balanced the risk that the OPR may be unable to identify all breaches of the provisions by decentralizing the process and placing part of the responsibility of identifying breaches in the hands of the tenderers and the public. Section 1.2.2.3 of the Act. Once a decision is made by the OPR to investigate an alleged breach, Section 41.2, the OPR embarks on what is a quasi-judicial mission. It is granted a wide discretion in the options available to it, including by requiring the accused person or public body to send to it documentary evidence or oral or written information. Further, the OPR has the power to examine and inquire into the affairs of a public body or person in respect of whom the investigation is being conducted. Subsections 42.1a, 42.4, and 43.1a of the Act gives it that power. The proficiency in which an investigation is carried out. And note this, the proficiency in which an investigation is carried out depends directly on the funding available to the OPR. So that's a constraint on its independence. The proficiency in which an investigation is carried out depends directly on the funding available to the OPR. To the benefit of the OPR in this regard, in order to prevent and deter malicious or unsubstantiated accusation against public bodies, as well as unwarranted delays to the process, the legislation renders the submission of false information as an offense, which is subject to a fine or imprisonment. Section 41.1.4. So when somebody is deciding to make a complaint, right? They have to ensure that the information that they have is not false, or else they might find themselves on the other end of the stick. So the Act also includes a provision for affording protection to whistleblowers under subsections 40 and 47, right? Confidentiality. With regard to its enforcement powers, once an investigation has been completed, the OPR has to inform in writing the affected parties and the Minister of Finance and the public official having responsibility for that body of the result of the investigation, and to make such recommendation as it considers necessary. Section 44 of the Act. The OPR's role in the enforcement of breaches is significantly strengthened by its ability, once there are reasonable grounds for suspecting the commission of an offense, to make a report to the Director of Public Prosecutions, who may take such actions as he thinks appropriate. Sections 45 of the Act. So that's an important point. If there's any grounds for suspecting the commission of an offense, the OPR must make a report to the DPP. Now, a public body or person who fails to comply with the direction of the OPR to ensure compliance under the Act is liable on summary conviction for a fine of $100,000. Section 14.2 of the Act. So if somebody doesn't want to cooperate or doesn't want to come before the OPR, he's liable on summary conviction for a fine of $100,000. Now, I don't know about, you all out there, but I find $100,000 to be a pretty low figure when we have bodies, public bodies doing, billion-dollar contracts, $100 million contracts and so forth. So that's something I feel that, could be addressed in the future. Now, the whole aspect of the investigation is a two-stage bi-institutional process. So in the first stage, the OPR acts as an independent administrative authority, charged with the power to hear, challenge proceedings brought by an aggrieved supplier, contractor, person, whoever it is, subsections 49 and 50 of the Act. The Act also contemplates that any proceedings brought must be completed within 20 working days. So once the proceeding comes in, it ought to be completed within 20 working days, thereby limiting the delay due to suspension of proceeding or contract performance. So if you're within a tender process or whatever it is, you want this out of the way quickly. These provisions effectively balance the interests of all parties in the procurement procedure, including the applicant, the procuring entity, and all other qualified suppliers, contractors, and so forth. Further, whilst the OPR can dismiss applications which it considers to be untenable, sufficient restrictions are placed upon it in exercising any discretion improperly, in that it is mandated to provide reasons for refusing to suspend any procedure or to dismiss the application before it, section 59. So the OPR just cannot say, we are not going to investigate this. It is untenable. They must give reasons for doing so. They cannot just do it just like that. In relation to sustained application, the OPR has at its disposal a number of actions when making a decision, including they could overturn the award of a contract or framework agreement and require compensatory payment, section 5010. The second stage of the challenge mechanisms comprise 3 independent persons with backgrounds in engineering, law, and accounting to review the decisions of the OPR. And this is as amended in section 51A. The existence of this second tier to review the OPR's decision. So if you're not happy with the OPR decision, you can go to like an appeal process. That's what the second stage is like, and challenge, right? So the existence of this second tier to review the OPR's decision ensures efficiency and transparency, and that the OPR will act dutifully and faithfully in considering breaches by public bodies. Capacity development and advisory functions. The OPR is mandated to issue guidelines under section 13(1)(c) of the Act and model handbooks, which public bodies are obligated to follow, section 13(1)(b). The OPR must also provide best practice advice in the conduct of procurement activities under section 13(1)(g) and promote the awareness of public bodies and the public procurement issues, section 13(1)(l). So if you over the last couple of months, since October last year, you would see that the OPR has been doing what is called a stage 1 registration. And they're now moving to stage 2. This is what they are doing, promoting that awareness of public bodies and the public to the procurement issues. So it is imperative to underscore that the success depends on the funding and resources given to the OPR. Again, I make that point. You know, the funding and resources given to it will determine how efficiently and effectively it can function. So a body with limited resources or untrained staff may not be able to disseminate meaningful written material, including standard forms of contract, Section 13(1)(p), and standardized bidding contract, Section 13(1)(d), to the public in a timely manner. Disposal of real property owned by the government on behalf of the government. Now, arguably, the most problematic function that has been entrusted to the OPR is that it is required to act for, in the name of, and on behalf of the state, to dispose of real property owned by the government, Section 13(1)(o). So in so doing, it is subject to the government's direction and control, as it must act in a manner as the government may consider appropriate and desirable. Now, I know our colleague, Afra Raymond, took issue with this. Took issue with this problematic function, but it's still there. Now, recent amendments to the Act have caused unease with the public, as the state further limits the jurisdiction of the OPR. Anybody noticing some kind of familiarity as to what they did to the Central Tenders Board? Piecemeal amendments and now limiting of jurisdiction. These amendments have been included in the Act, which has received an assent. So far it's received an assent from the President, so it's law, but it has not yet been proclaimed. And these are government-to-government arrangement, G2G, and public-private partnership. The recent amendments to the Act Section 7(1) exclude both government-to-government and the PPP from the OPR's oversight. These exclusions are inimical to the public interest, since they represent the two largest types of contracts for construction or supplies. Section 7(5), as amended, creates exemptions for these services provided to public bodies or state-owned enterprises in respect of A, legal services, B, debt financing services for the national budget, C, accounting and auditing services, D, medical emergency or other scheduled medical services, or E, such other services as the minister may, by order, determine. The financial services exclusions in the newly inserted Section 7(5) would likely exclude PPPs. Legal and accounting auditing services are essential to govern the transactions of public monies. So, in a nutshell, this is the PPDPPA. It's clauses that relate to the OPR and what has transpired since it first came into being in 2015. So that brings, for me, an end to my presentation. And of course, the amount of people here, I'm sure that there are going to be a lot of questions. Thank you very much. I now move on to questions.
Nigel Ramsey here.
Yes, sir.
Are you hearing me?
Yep.
Yes, I am.
Right. My first question is, looking at the significant changes, especially the last portion that you read in relation to let me I want to call it by what it is, the cabinet in relation to oversight by the office of the public, the regulator, the office of the procurement regulator. How is it, do you think, in your opinion, that it was correct to say that this could be passed with a simple majority when the act coming into being needed a 3/5 majority?
Nigel, the position with that is that the law of the land allows government to do that. It may not be what we want or like, and if you notice, I said this had the greatest of unease with the public. It's not something that the public has accepted, but it has happened. The government has a majority in the House. The only way that will be addressed is when something does happen and somebody challenges it in a court of law. So we wait to see. No more questions? Ricardo, we have any other questions?
I'm not seeing any questions in the chat. That was a lot of content. Everybody quiet.
I was too clear or what?
Probably.
Derek?
Yes.
Could I ask, at what point will the Central Tenders Board be done away with? Is it that the whole act has to be proclaimed?
Yes.
Or
yes. The act has to be fully proclaimed for the Central Tenders Board to be repealed.
So in the interim, then you would have this, both the Central Tenders Board and the Procurement Regulator dealing with contracts?
Side by side. And you would have noticed in the newspapers that there are certain ads for contracts sent out by the Central Tenders Board. And you will also notice that some of the special purpose companies are still acting with the rules that they have, which are supposed to be in congruence with oversight of Central Tenders Board. So yes, that is happening. We have both pieces of legislation running side by side. And I'm not sure that was the intention.
Yeah, but would you share the opinion that what you're doing is concentrating the whole idea of procurement into one body as against the Tenders Board and the different state companies and whatnot, with the position that you could get the same sort of negative occurrences, but the difference being that you would not be able to touch that regulator because he is only, well, he is, as you said, appointed by the president, but answerable to the parliament only.
Right. So he's sort of immune to as well. You know, you can't take him to court or anything like that. You know, but
isn't there a serious disadvantage associated with that? And is that the reason why one is moving a bit slowly with this whole arrangement?
I think the whole movement is deliberate. If you look, I mean, to be quite frank, it took decades for government to amend the Central Tenders Board Act to create the chaos that they did. Not only that, when you have 32 special purpose companies all putting out bids and so forth, the information that we provide each time we bid, we have to do it over and over and over to each one of these. And it was costing a lot of money, a lot of wasted time and resources. Now, all that information goes into this central repository, you know, and that all the people who are pre-qualified for that category or whatever it is could bid for jobs depending on which agency it comes out on. So you only bid basically on the project, you know, because a lot of your information has been already inside of the system, you know, and that could save a lot of cost. But by the two systems operating as they are, and by piecemeal amendments already happening to this procurement regulation, as you see, the powers that we were given to this procurement regulations that were taken away from the Central Tenders Board over the decades. If you notice, it's been taken away before we even proclaim this whole act. It's been taken away before, you know, through piecemeal amendments before the act can be fully implemented. So what are we going to get at the end of the day, which is the big question that we have to ask ourselves? We're going to get now what is called a centralized repository that would have more or less the same limited powers as the Central Tenders Board. By the time they proclaim the thing.
One more question I want to ask. As it exists now, in the ministries, a PS could spend up to $1 million without going through Central Tenders Board. And if it's above $1 million, then they have to involve Central Tenders Board. If these two systems is to be operated parallel until the act is fully proclaimed, then a lot of ministries could keep doing what they're doing and split up projects and keep them under $1 million and just do what they are accustomed doing. Is that a fair assessment?
It's a fair assessment, and if you notice that we've had our own colleague Afra Riemann together with a number of the commercial bodies, the TTMA, the Chamber of Industry and Commerce, the Trinidad and Tobago Institute of Coalition Services, all been articulating to government to fully proclaim this act, you know, and repeal the Central Tenders Board and stop this dual position that we have, you know. So if you notice, that's what they've been articulating. This thing was first, you know, passed, you know, assented to in 2015. They took 3 years to get a regulator in place, you know, and we now have 2021, you know, and less than half of the act has been assented to. And significant amendments have been done.
So do you see that there is wisdom in attempting to concentrate all this power into one body?
Well, it does have its advantages, you know.
Assuming that you get someone with the mentality of the soon-to-be ex-president of the US. You know, is it, I'm just asking if it is wise, if there is really wisdom to devolve all this power into one institution or one person.
Well, Dennis, it does have some advantages in that we create greater transparency, greater accountability. We have now a system of appeals, you know, and one of the things that we have to understand, you know, which we didn't have with the Central Tenders Board Act, is that you know, and Professor Sweet pointed this out to me very, very clearly. Procurement in this act is not just tendering. An offense of procurement is not just during the tender stage. Procurement is from the inception all the way to commissioning. So if a procurement body, like one of these special purpose companies, were to carry out an act in such a way that affects, you know, something during the procurement life cycle, all the way to the end of the project, you can make a complaint to the Office of the Procurement Regulation. So it's not just tendering, it's also during construction, also during defects notification period to the end. So if they was to say, terminate your contract, you know, wrongfully, that would, and you find that that's a breach of the procurement regulation, you can make a complaint. You know, so it's not just tendering. So this procurement legislation creates a greater advantage for us for the whole of the procurement life cycle of a project. So it does have some advantage.
But are there any disadvantages that we need to look out for?
Well, as you saw, the amendments of Section 7, you know, by removing certain services and certain types of procurement from the jurisdiction of the OPR, which previously existed. So we do have some disadvantages, some that we didn't like, but we have some great advantages. You know.
Mr. Aldridge, there's a question in the chat.
Sure.
Derek, you said on a number of occasions that the proficiency of the OPR is dependent on funding available. Where is this coming from? Given that funding will come from the government, isn't this dependence on government funding a conflict? What are likely to be the biggest expenditure items under the OPR?
So, as we've noticed, you know, and I pointed that out, that's one of the things I highlighted in red, you know, that the functioning, the proper functioning of the OPR is dependent on if it's receiving, you know, funding for its resources. So, an area that might likely be where funding might be required was if the OPR was to get a lot of challenges or a lot of complaints or a lot of, you know, things to investigate, right? And they don't have the funding to carry it all out. They will have to prioritize what they can and cannot do. And remember, they have to give reasons if they were to dismiss anything. One of it might well be a lack of funds. You know, so when we say it's an independent body, it has the same level of independence as any service commission. It's protected with under law, being independent. But where its resources come from for financing it, you know, right? And one of those areas also that I identified was the monitoring function. The monitoring function is cumbersome, you know, right? Burdensome and has a lot of bureaucracy, you know. So that is an area because they have to carry out that those powers all the time, right? So if you look at this as states monitoring powers, notwithstanding that it ensures improvements to the system, because this is where the improvements to the system can go, they are predicated on burdensome information collecting and reporting requirements. And it's more bureaucratic procedures, which can be cost and labor intensive. And that's where a lot of monies, you know, might be required. Somebody have their mic on?
I think it's
getting feedback.
No, there's another question coming in.
Sure.
But if you are finished with Mr. Doyle's question, I don't want to.
Yes, I've finished. I've identified, you know, the constraint.
All right. I think some of the feedback was coming from Mr. Ali, Rick Ali. I think he has a question.
Sure.
Rick? Okay, you may be having some challenges.
Well, I see we have 50 people out there, so we might get some more.
Yeah.
Question from me, Derek. This is Paula Drakes. Do we have any updates as to, or with respect to the regulations that were supposed to be, provided for, again, for public? Because I think somewhere in the debates in Parliament, I heard something about regulations, but
yes.
I'm not sure regulations for what, or especially when it deals with the real property part of the Act.
Right. So the Act provides that they must have regulations designed in order to provide its operational capabilities. A lot of those regulations are being drafted at the moment. We've been told that it's been substantially completed, you know, and that is what is going to be required in order for some of the other sections of the Act to come into being. Those regulations have to be drafted first. So at the moment, we don't have a time frame from the government as to when they're going to be bringing those regulations to Parliament. But it shouldn't take long because those are going to be approved with what is called affirmative, you know, affirmative resolution. So it's only a matter of laying them in the House, you know, once they've been agreed upon. You have anything else there, Ricardo?
Doesn't appear so. You were very thorough, which is good.
Yes, thank you. Well, I suppose if we have nothing more,
we can conclude this. We can
unduly delay people.
Yeah, well, we can conclude this meeting. It lasted just about 1 hour. We started at 5:05. It's 6 o'clock now.
I thought so.
Yeah, it's 6 o'clock now.
Very good. Excellent.
And yes, So thank you all for coming out. If there's any final words anyone needs to share,
you could also send any questions, you know, and we will try to answer them. Send, you know, post them back to you.
Yeah.
So I'm really thankful that so many people attended this session. I hope that I was able to provide you with a lot of it. I have to thank my friend Attorney at Law Sonia again, who did this MSc in Procurement Law, and you know, was able to share the thesis with us. You know, it's very good.
Right. And as we conclude,
thank you all very much.
Yes, and as we conclude, just a reminder, this recording will be on our website. We will advise you when it is up though. CPD letters would be shared. If you're having any challenges, you could always reach out. And if you need any additional questions, as Mr. Aldridge said, yeah, shoot us an email, give us a call. We'd be happy to answer it. So yeah, that's it. You all have a good day.
Bye-bye.
Okay, take care.
Thank you, Derek.
Good evening, everyone.
Thank you very much.
Okay.
Thank you very much, Derek. Bye-bye.
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 Bye-bye, and thanks very much.
Thank you.